The suspect in Charlie Kirk's murder is facing a judge today. Attorneys representing the 22-year-old say he will attend the hearing virtually. His defense will tell the judge if they want a preliminary hearing to determine if there's enough evidence to go forward or if they want to schedule an arraignment instead. The suspect is charged with aggravated murder, and prosecutors say they plan to seek the death penalty. ABC News legal contributor Brian Buckmeyer is here with more on that. Hi, Brian. So what does the defense have to consider right now?
So kind of take a step back and just think about this, right? In most states, and even oftentimes in Utah, they just present their case to a grand jury, and the grand jury will determine whether or not there's probable cause, and if there is, it goes forward. But in Utah, for the most part, what they do is they have these preliminary hearings. And so for the defense, the question is, do you waive your right to a preliminary hearing, or do you do it? If they waive it, no hearing, you move on, and you do the arraignment, you push towards a trial. If you don't waive it, then there's going to be like this mini trial where the prosecution puts on witnesses, and you get to cross-examine them. Now, do you often win these preliminary hearings? No, but you do often get an opportunity to get some information that you might not get until later on the trial. But the fundamental question becomes, especially with a high-profile case like this, is the juice worth the squeeze? Do you want the public to know all the good, the bad, and the ugly of your case, or do you want to kind of work on it, maybe negotiate a plea or work on a trial down the road? So it's a give and take.
So where do things go from here?
Yeah, so the defense will make the announcement as to whether or not they're going to waive a preliminary hearing, meaning they're not going to do the hearing and they'll go to an arraignment and it'll progress in a similar fashion as if there was a grand jury. We as a public won't know the information until or unless there's a trial. Or they're going to have the hearing and they're going to try to push the bounds of the case, either in an attempt to try to get some charge dismissed or just as a kind of an evidentiary hearing to try to figure out as much as possible to see how they either are going to change this case in the court of public opinion or in the court of law.
All right, Brian Buckmeyer, thank you.
My pleasure.